present Sammy Knapp.
Well, thank you very much. I'll try to do it without a microphone. And it's the one right here, right? Yeah. Okay. My name is Sammy Knapp. I've been a police officer for 42 years. I've been the constable here since 2012. I was a 29-year veteran of the Plano Police Department. Started in 1973 for Grand Prairie Police Department, and then I went to the DFW Airport. And so I came to Plano in '80. I started their motorcycle unit, their DOT unit. I was the senior hostage negotiator. I don't know if y'all remember back in 1997 when they had that Rigsby daycare hostages held, 82 of them. I was the first negotiator for 12 hours. Then I was relieved, and he asked for me when he got out. Before he gave up, he wanted to talk to me. We had gained that much rapport with him, so we got 80 plus people out of there, 80 children and 4 adults, and it was a very gratifying situation. I've been asked a lot of times, what is a constable? Where did it come from? How did it happen? Where, when, and why? We've been in existence in the state of Texas since 1836, actually 1823, but in the Constitution of 1836, we were appointed before the first sheriff. It goes back to 1066. Matter of fact, the Roman Empire had the constables, and at that time they were the armaments and the stables and the settlement, and they did the riot control back in those days. In the United Kingdom, where we came, a lot of our British laws came from over there. The first lady in law enforcement was in 1917 in the United Kingdom. So she was a constable. A constable is a police officer. We are certified under the Code of Criminal Procedure. 2.12 tells the who are law enforcement agencies, and it's the sheriff and then the constable. And then it goes down to municipalities, into the airport police, DEA, and all that. So, and we've been asked, why do you have a gun, and can you write a ticket? Can you put me in jail? Matter of fact, the commissioners were so kind. We used to have constable written on the back of our cars, and people would blow by us. We're not in the traffic business. However, if we're in uniform and in a marked car and someone blows by us, the expectation of you as a citizen is for us to do something. We don't have to issue the citation, but they say, you're the constable, you can't write me a ticket. Well, too bad, too sad, press hard, there's 3 copies, you know what I'm saying? So we can issue citations. In the colony, the Plymouth colony in 1632, was the, and by the way, back here on the back, I left some stuff that you can read when you get home, but it's basically covering this right here. In 1632, in the Plymouth colony, there were constables back then. In 1823, the first 2 by Stephen F. Austin, who is believed to be the first Texas Ranger to be killed in the line of duty, appointed 2, and the first guy was Alley, A-L-L-Y, and he was appointed the first constable in 1823. And what they did was the judges, the constables went out and got the people and brought them in to the court, and that's how they had the hearing back then. And then in 1836, it says that some of the 200 renegades they called constables back then helped Santa Anna in the Battle of the San Jacinto. So but we've been around quite a while. Again, like the Constitution of 1836 is where they wrote us in as a law enforcement, constitutionally bound agency, where it has to go through an amendment to the Constitution to do away with our office. Shortly after this, we were considered the conservators of the peace throughout the county. And under the Article 5, Section 18 of the Constitution is where our authority is found. We serve 4-year terms. I'm in my 2nd term. I was a deputy 2 years before I got elected. We're on the same presidential cycle, and we're associate members. We can be appointed special deputies by the governor for catastrophes like hurricanes, tornadoes, floods, things of this nature, because we have the authority in our county and any other county to serve our papers. So any contingent county that we touch, we have the authority there. The sheriff can only go in Collin County of the authority. However, he can make arrests like we can. But we have the contingent county of anything that touches Collin County. Plus, we have the authority all over the state of Texas to make warrantless and warrant arrests throughout the state of Texas. So the constable is not just a mailman with a gun that goes around and delivers papers. We actually are certified law enforcement officers. Each constable has deputies. I have 9 deputies working under me, 6 reserves, and 2 clerks. And in that, what they do is we go out, and I'll show you just a minute some of our duties that we do, but we are bound under the Constitution to carry out our law. Like I said, we have 4 precincts in our county. Tarrant County has 8, but we have 4. I'm in precinct 3, which goes from Dallas to Fairview to Seis Lagos, all the way over to the west side to Midway Road. We're in 9 municipalities, our precinct is. So we have 10 deputies, which is twice the size of the other precincts. And we had like 10,292 papers last year. That's how many papers that we were issued and we served. Our core duties are to bailiff the court, which we have 2. We have John Payton currently, and we have Chuck Ruckle. So we have 2 courts that we bailiff. Then we also maintain the court for anybody that's coming and going, for people that are called in for jury duty, stuff like that. Then we line them up and get them ready for the court. We serve the warrants, all the warrants that come out of the JP, and that includes DART, the Collin Police, the DPS, the Toll Authority, all of those warrants, SPCA, the Collin County deputies, our deputies that issue citations all go through the JP court. And if it goes to a warrant, then we serve those warrants. And then we make arrests before, and we have made arrests before, during, and after the trial for contempt or show cause. The judge, Peyton, is real big in juveniles, and we have taken them from there straight to the juvie jail. And now that it's been taken away from him mostly, and we have not made that many arrests as we used to. Our civil deputy serves all the civil process. Everything that comes through our office, out of county and in county, that's in our precinct, we serve. Our guys don't patrol. However, in our building, if y'all remember, our office is at 920 East Park Boulevard. We're in the backside of, there's 2 county buildings. The first building has the women and children building, has the veterans place. It also has where you get your passports, the district clerk's office. It has women and children. It has a clinic. And the second building is 920, which is the constable and the tax assessor that you get your tags and stuff. And we're on the second floor there. So when they have a panic alarm at the other buildings or our building, we're the one that they call. So we respond. So basically we are a patrol also. We're also a transport deputy. When one gets arrested, then we do the transport. We don't call Plano, we don't call the Collin County Sheriff's Office, we do it ourselves. So when you go to the Sheriff's Office, they have their own patrol, they have their own mental health deputies, they have their own civil deputies, they have their own transport deputies. We do it all. So we're everything. Like I said, we do the mental health. We don't go to Green Oaks anymore. We now go to the mental retardation that they have here in town. The truancy deputies, we do all the juveniles, everything that comes through our court, we take care of, we transport them. We do the warrants. We have warrant deputies. And if y'all have a question, throw it out, because I told Mr. Steve that I'd do it about 20 minutes and let y'all not hold you very longer than that. The bailiff, we have 2 bailiffs. We have 1 full-time and 1 part-time. We asked for a new bailiff in the budget this year. What we're doing, we're taking deputies off the street to do 1 court, to bailiff that court about 5 hours a day. So what we're trying to do is get another deputy to do it full-time to keep these deputies on the street and serving their papers. So And these are some of the things that we do, some of the papers that we see, and I'll go over some of these. A civil citation is going to be your first notice that you've been sued. They call it a notice to where you've been in a car accident, or the plumber didn't fix your house like you wanted him to fix it, so you sue them in the small claims court, which is the JP. Right now it's $10,000. They tried to raise it to 20. They're trying to negotiate it to get it to 15,000. We do criminal subpoenas, juvenile subpoenas, writ of garnishments. So if you get your wages garnished, then we go to the bank and we give the notice to the president of the bank, and they hold the funds till the court hearing is held. Garnishment notice of show cause is generally a juvenile case that comes from the juveniles, and they do this. Child support notices, civil subpoenas, truancy subpoenas, evictions. A lot of people say, what do you do with evictions? The evictions are when I'm living in her rented house and I don't pay my rent, then she tells me to move. I don't move, then she goes to the JP and files a case to have me evicted. Then after she pays her money to have me served, that person that's living there, so I show up in court and I tell the judge why I should or should not be evicted. She tells the judge why I should or should not be evicted. Then the judge rules. Whoever wins or loses has a 5-day appeal. After the 5th day, we don't hear back from you. Then on the 6th day, she can file a writ of possession, which we go out and actually we don't do the moving. She would have to furnish the movers and to get all the items out of the car. And I know y'all seen yards that had stuff piled up in there. That's us. And I'm going to be honest. Nobody likes to see us because we're negative. Everything we do is negative. We kick people out of their houses. We tell them they're being sued. We take children from them on DNA testing. So there's a parental thing, and he's saying I'm not the dad. We have a court order from the judge that we go take the child, take them to a testing center, and then we give them back. It's not that we take them. Or we do writ of attachments for kids out of state that they come across the state lines and are holding them, where they shouldn't be, interfering with child custody, then we get involved in it. But everything we do is a court order from a judge. Everything. The writ of possession is when we go out and move. The protective orders is generally, protective orders, we have what we call a kick-out order also, to where we go in and she and I are married, and she goes to the judge on ex parte and tells the judge that I have beat her up or assaulted her. So there's usually every time going to be some type of family violence. And when we go out there on a protective order and a kick-out order, we ask the one that's being accused to get enough stuff to live until the court date. You can't come back here. Then they are given their court order and they're told what their violations and what the repercussions are should they violate the order. So we do that. So we've had some issues safety-wise for that. The injunction is just like stop and just quit doing what you're doing, and it's a court order from a judge saying stop doing that. We don't hardly have checks anymore. Everybody does the debit, but we still do have hot checks. We have a payment delinquent order, PDOs, that when you go down and get your license plate and you write a hot check for the license plate, the tax assessor will tell us who they are, where they live. We go out, knock on the door, and say, listen, you owe the tax assessor for the amount of the money plus the amount of the fee for the return check, just like we would for a hot check. And if they don't do that and say, I'm not going to do that, well, we go take their license plates off their car. So then they get stopped by every popo in Collin County. And then they decide they're going to go ahead and pay. Again, we do the traffic warrants, peace bonds. I've been in the office 8 years, and I've seen 0 of those. Those are far and in between. Writ of attachments, we have done it for people and property. Contempt commitments are normally within the court, bond forfeitures. Writ of executions, order of sales. We do sell people's property, like the homeowner association files a lien, they lose their case, we sell their house. We sell it on the first Tuesday of every month, and it's on the Bloomdale, the actual main courthouse steps.
Man, you are bad news when you show up.
Well, we're bad guys. Nobody likes us. My dog even growls at me. But we do. But the people call us all the time about the foreclosures. We don't do that. That's held at the what I call the sub courthouse at the auxiliary, and they do that also the first Tuesday of each month. Writ of attachment of property, we do, like I said, when we sell. Writ of sequestration is basically, am I in your way? Is basically a repossession. Someone's not paying for their car, they go to court. We go out and get their car, tow it to a safe place. They can replevy that car and get it back but it's a court that you have to go through. And sequestration is basically a repossession. The turnover order is where I have a company and I have been sued and I own a bulldozer and a dump truck and some other equipment. I go to you and I say, we got a court order, you need to turn it over. And they have to give it back to us. So we have to make arrangements to get them picked up and taking them to a safe place until we have the hearing. So it's a lot more than a lot of people thought we did, I promise. We like I said, we do mental health. A lot of that comes out of the judges, the JP's office. We try to let the local agencies do the mental health. We ask that Plano or Irving, not Irving, but Allen or Fairview, let them do their own arrest and let them do. But we will, if they can't do it, we'll go ahead and do it. But and we transport them to Green Oaks. Our operating budget. I've got the figures here. We did 413 forcibles, which means we knocked on people's door and said, Sammy, you have not paid your rent. You need to move. Those are $75 a piece. Then what we do is once you go kick them out, that's $175. So all of these fees are set up by the county on all of our fee structure. Everything that we charge, it's a fee. So we charge, so you as the taxpayers don't pay for this, the plaintiffs pay for these fees. So the plaintiffs and the juveniles in the courts that are held, a portion of $4 or $5 goes toward the defunct and the amount of everything that it costs. So it is, and the amount of papers that we did just by the fees alone, our budget was like 700. Our deputies and their benefits were like $700 something thousand, and just the fees alone was almost $800,000. So we're pretty much self-sufficient, but we still have other issues as far as cars and stuff like that we have to finance. That the commissioners they do our budget, and we go every year. We go before them, we submit our budget. They look it over, and then they decide what they feel that we should or should not have, and then if they don't recommend it, then we go in 3 days. We plead our case to the commissioner and the judge. Again, this is back in 2014. I did this because, like I said, he and I just met at the polls, and he was telling me he needed some money, and I told him I'll come help him out. So I jumped up and did this. But we had 165 arrests back in 2014. We transported, the hours to do that was 169 and a half hours. So that means the deputies that serving your papers and things are tied up now, transporting prisoners. Back then, that like I said, since the juvenile has been reclassified and redone, it's reduced from that. And the PDOs we had just for that one month that we did this one in had $10,000. So that many checks are written in that year for hot checks for your license plates. Wow. So people are still hanging paper. You know? Yeah. But the bailiff hours, we had 1,226 hours. Now that is combined to the 40 hours a week that the deputy that does John Payton's court, and then the other deputies that go in and they apply their hours toward the bailiff in the other court. So, and by the way, the Judge Payton, when he had the juvenile, we were doing it at the Allen High School. They have a little mock courtroom there, and we were going there, and also Lovejoy. We went to the Lovejoy admin where everybody voted. We had Lovejoy schools. But Judge Payton is doing Plano, Allen, McKinney, Lovejoy. There are 5 or 6 school districts that he's doing. So we're doing a lot of stuff through his office. And this is just a short video. I just wanted, it's an older video, but it'll give you some idea of what's going on.
For how demanding and dangerous the job can be. Because the life is being there for orders enforced, I call it consequences. Whether it is to collect debts, child support, evict tenants, prevent domestic violence, make arrest, or attach children from those whom are not supposed to have them, I know firsthand that our constables have all the necessary authority, training, and expertise necessary to ensure that court orders are effectively enforced.
It's always in the back of our minds when we serve protective orders that dozens of victims of domestic violence are killed every year in Travis County.
We were given a protective order to run and locate an individual knocked on the door. As he was men began to open the door, the man pushed open the door. He was reaching back for a drawer. Inside the drawer was a gun, along with 2.5 ounces of cocaine. After the arrest, we found out that the individual was on the top 15 most wanted list as AAP.
Did you hear it?
While executing eviction in Pflugerville, entered the residence which appeared to be vacant. Constables noticed a female at the top of the stairs, start from the right side, pointed a .357 Magnum at me. I was able to talk to her, and after about an hour of negotiations, I worked my way up the stairs, was able to tackle her, took the gun away from her.
Well, this is one of those typical evictions. When we got inside, we had this naked woman come at us, screaming out of her apartment.
Now, this
Took her back
is
to her
a
bedroom,
true
told her
deal.
She had put some clothes on, and then she picked up a butcher knife that was in there. That's when eviction stopped being normal.
There was a woman on Old Torp that had been struck by a vehicle in the middle of the intersection. I was the first on scene, was flagged down by concerned citizens there. She had been badly injured. I was able to block off traffic and call for EMS and keep her from getting hit by a vehicle.
I was on my way home in my market patrol car on Mopac, approximately near Anderson Lane, when I noticed a vehicle going southbound in the northbound lane. I was able to make a traffic stop on the vehicle. The driver was found to be intoxicated. He was taken to jail and booked in. While I was out at the scene, I was advised by an APD officer that he really appreciated my assistance on taking care of this problem, because within the next couple of minutes, this would have sure been a fatality accident on Mopac. So I probably saved someone's life by being able to take this DWI off the road that night.
I received a writ of attachment for 5 children. It was common knowledge by all law enforcement that this family is very dangerous. There was a meth lab there, and the grandfather put a 9mm gun to one of the caseworkers' head. We were able later to retrieve the children from the courthouse.
We were getting several complaints from the citizens and various churches in our community about the drugs and prostitution problem. We responded to their complaints, and as a result, we were able to make 15 arrests. We wrote 11 citations for prostitution and narcotic possession.
While on patrol, I observed a couple of juvenile males running back and forth across the street. A little leery because one of them had a sword. So as I stopped to interview him, I noticed a bulge in one of the juveniles' back belt pant area. Did a quick pat down for officer safety, and the juvenile ended up with a 9mm pistol.
If the public really knew what the constables did, they would really have a different perspective on how we do our job. I mean, they just don't know. When the public says, well, all you do is this, and you're not really the police, well, do y'all carry guns, or can y'all like this, or can the constables as a whole, we have it tough because elements are out there. I mean, the scene changes every day. It's never the same. You know, an Austin police officer can have the same 911 call 4 times in a row. If a constable deputy has 4 written possessions in a row, it's not going to be the same. One is going to be a crack house. One is going to be a mental health person. One is going to be where you get there and the person's not going to want to come in. You just don't know. I mean, you just don't know. And it doesn't matter whether you're in uniform or out of uniform. The job is still the same.
We know that many of the people we serve are already under a great deal of stress. There are often things going on in their lives that can cause them to act irrationally and make poor decisions. I know that each time I knock on a door to serve process or enforce a court order, I have to be prepared and ready for anything.
And that was 86 killed in 2006. There's been 92 killed now since then. And that's pretty much it. But it's not, and you got to understand, we have the right on some of these written possessions where the lady was mentally ill. We have the right to do what force necessary, in fact, taking them to jail and place them under arrest. So what we do is not just run around and drop papers at the front door or put them in the mailbox. They won't answer the door. We have alternative service and we do that, but that's pretty much what we do. This was done by the Travis County, and I thought it was pretty good. It tells a lot of stuff. It's kind of antiquated, but it still has the point across. Thank you very much. I appreciate it.
My name's Derek Baker.
Hey, Jim.
And I've done a number of these forums. This one probably won't have any fireworks like some of the others. In fact, Mr. Johnson's done several of these and we've had the opportunity to meet. As he knows, there's a number of questions and then we're going to have a lightning round. The questions are 2 minutes apiece. We'll run through those. It's 14 questions if we get to it. This probably doesn't work, but you can still hear me.
Yeah.
And then we'll do a lightning round, which is yes, no, or pass. And they're not intended to be gotcha questions, as you know, but if you try to elaborate, we'll cut you off. And then if someone has a question about those, that's why they're here. Come and talk to them. Okay, good. Yeah, we're going to do a 2-minute intro and then 1 minute apiece. Yep, for 9 through 12. Got it. Are you ready for us?
I'm ready.
Can you start with a 2-minute intro?
I will do that. My name is Randy Johnson. As you know, I'm running for Court of Appeals. I'm in a runoff with Jim Pikl. It is a pleasure and an honor to be here. I'd like to thank the Allen area Patriots for inviting us. I'd like to thank each and every one of you for your commitment to conservatism and keeping America great. This is a very important race because right now, the Court of Appeals in Dallas, they're all Republicans. There's 13 judges in the Court of Appeals in Dallas, the 5th district, which covers 6 counties, and I'm running for an open seat. And it's very important that we get someone who is qualified, who's experienced, and who is conservative to fill that open seat and keep this court all Republican. I am a Christian, I'm a constitutional conservative, I'm a father of 2. I've been married to the same wonderful woman for 37 years. She's here tonight. She's the reason I know there is a God, the fact that she's still with me. I'm a 5th generation Texan. I was born in Dallas, raised in Dallas, and I've lived in Collin County since 1985. I believe I'm the most qualified candidate for this race because of my 33 years of combined experience prosecuting and defending both criminal and civil cases in the trial and appellate courts. I don't believe this race is about who has the most endorsements, but who is the best qualified. I'm the only person in the race that's triple board certified. I'm board certified in civil trial law, personal injury law, and workers' compensation law. I'm also on the Collin County list of attorneys that are approved to do court appointments in criminal cases. I'm the only candidate in this race as a Republican or a Democrat that has extensive experience trying criminal cases on appeal and in the trial courts. So I'm here today asking for your vote. I will tell you that the 3rd candidate in this race, Perry Cockrell, has supported me in this race. He has asked his voters, the people that voted for him, to support me, and I hope that I can earn your support tonight. I look forward to answering your questions. Thank you.
Excellent, and he may know this, but we have a timekeeper in the back. Mr. Mercer is gracious enough. He's going to be, Steve, correct me, there's the stop. He's going to hold something up at 1 minute, at 15 seconds, and then it's stop. And the questions are going to start easy. So here's a softball for you, Mr. Johnson. How many primary or general elections in the last 10 years have you failed to vote in? Please explain.
I voted in all the general elections, and I believe I voted in all the primary elections. I may have not if there was not a contested race on the Republican side, but I think I voted in all of them.
All right, see, I told you we'd start with some softballs, but we'll go progressively more difficult. How long have you practiced law, and you've done this briefly already, but share any board certifications, awards, or honors you received relevant to the practice of law? I'm going to add one thing to this. And share anything particular that's notable about the seat you're running for that's not the same as district court. A lot of people don't understand the difference between district court and the seat you're running for, why that's relevant.
Okay. I was licensed in 1984, so I've been practicing law a little over 33 years. I am board certified by the Texas Board of Legal Specialization in 3 areas: civil trial, personal injury, and workers' comp. It's very difficult to get certified in one area. I'm certified in 3 areas. You have to take a test in order to do that. You have to be recommended by judges and attorneys that you've appeared before and against. You asked about other honors. I'm also AV rated by the Martindale Hubbell, which is the highest rating you get for competence and for professionalism and ethics. The 5th District Court of Appeals is important because it hears both civil and criminal cases, and I've had experience doing both civil and criminal cases. It's also important because it serves as a check and a balance against the district courts, which are the courts that appeal their cases. The cases are appealed from the district and county courts into the Court of Appeals. So they are a check and balance against that to make sure that the cases have been decided correctly.
Describe for us the say the organized approach you're going to take to handle the immense workload of the appeals court judge. If you want, you can explain the difference between district and appeals court and why that workload is so significant.
Okay, and there is a big difference between district court and the appeals court. In district court, I have a very heavy trial docket, so I may have 3 and 4 cases set for trial every Monday. I have to be ready for all of those, and you usually don't know until the Friday before whether or not you're going to go. So I've always had a very heavy docket, and I've had to establish calendaring systems, ticklers, things that make sure that I keep track of all my deadlines. Otherwise, I couldn't do that trial practice. There's a tremendous number of deadlines. In the appellate court setting, you may be handling 1 or 2 cases at a time. You may hear cases once a month, and then you have cases that you're working on your decisions and you're researching and reviewing. I would bring the same work ethic to the appeals practice that I had for trial court. I also think that I'll be able to get started quicker on this because I already have the criminal court experience, and I won't have to learn on the job as will my opponents in this case. So I'll be able to bring that to bear and use that in handling my docket and my caseload as an appellate court justice.
Share some of the most, say, common procedural mistakes made by trial judges. You're the arbiter of those if you win.
Yes, trial judges, by and large, the trial judges do a fairly good job. The most common error is the failure to preserve error by the trial attorneys. That's the most common area that I've seen over the years. But probably the most common area that I think that the trial judges make are in terms of how they handle and deal with motions for summary judgment, where you've got expert witnesses and how they judge and review the expert witnesses and their qualifications and whether or not to exclude them or to allow the evidence. And I think that's an area where a lot of trial judges have issues.
I'm going to pick a very popular case that people cite often and see if you would be willing to share some pertinent facts of the Kelo decision, and then how the Supreme Court maybe came to its decision and what your view of the decision was.
Which one's the Kelo decision?
Well, so the Kelo versus New London decision, the decision about essentially eminent domain, one of the most significant private property rights cases in the last 15 years.
And I'll have to tell you, I haven't reviewed the case.
Well, I'll tell you what I'd like you to do, other than Roe v. Wade, is pick a Supreme Court case of significance in the last 20 years the material facts of that and why that was decided wrong.
And can I instead pick a Texas Supreme Court case?
Yes,
Since this is a
Texas Supreme
bench?
Court would be great.
Okay, because everybody talks about Roe versus Wade and,
Yep.
and that being wrong. I would like to talk about two cases that are near and dear to my heart. One is the Manbeck case, which is a case that involved an employee of a government entity who was who had a workers' compensation claim. They successfully had that workers' compensation claim adjudicated in their favor at the administrative level. The city appealed that to the to the district court. And in every other context where you have workers' compensation cases, if a carrier or a city up to that point appeals a case to the district court and then they lose again, they have to pay the winning party's attorney's fees, the injured worker. The Texas Supreme Court overturned about 30 years of judicial precedents and said there's sovereign immunity, and so the government does not have to pay the attorney's fees even when they bring a case they shouldn't have brought and lost. And it's wrong because there actually is something in the Texas Labor Code that says that you should be able to bring that kind of case, and they ignored that and said that there wasn't an exception to judicial immunity.
Thank you. If you would, name a judge, either local, state, or national, with whom you greatly admire, and explain why.
Well, locally would be Judge Ray Wheelis, who I've known for many, many years and who just recently has been tapped by Governor Abbott to be the regional director, presiding judge. There's also, and this goes way back, there's Justice Jack Pope. He was on the Texas Supreme Court for many years. He was a Democrat, but he was appointed to be head judge by a Republican governor. And while serving many, many years, he established a lot of things that now control the court and protect against abuses of discretion by Supreme Court judges.
We have a few seconds more. Tell them, since we know Ray, why Ray?
I've known Ray for a long time. When I first, years ago, under the old workers' compensation law, I was representing insurance companies. He represented the injured workers. He was always prepared, he was thorough, he was knowledgeable, he was fair, and I found him to be the same way as a county court judge and as a district court judge. And I can tell you, even though I've known him forever, he will rule against me in a heartbeat. He follows the law. He doesn't let special interests dictate how he's doing things. He does things the way they should be according to the law, and is a very hard worker.
Tell us an accomplishment that you are perhaps the most proud of. It could be personal or professional.
Well, the thing I'm most proud of is I picked the right woman to marry, and we have two really great kids who are very successful at what they do. They've never been a problem for us. They've done the right thing. Professionally, something recently that I was very proud of is I represented a fireman's widow and their son in a case where he got cancer, and we won at the administrative level. In that case, the city appealed it to district court. They had a summary judgment that the court was wrong and entered wrongly, and I was able to get that reversed, and most recently they dismissed that case. So they allowed my widow to get her widow's benefits and the son to get the money he needs to be able to finish college. And I was proud to help them, and I'll tell you, I haven't taken a dime for that. I represent maybe a dozen firefighters and their families, and I've done it free, and those cases are very time intensive, but I'm proud to have been able to work with the firefighters on those cases.
The Iowa, you may have heard about this, some of you as well. The Iowa Senate just passed what they refer to as a heartbeat bill, and it will effectively ban abortions after 5 weeks. Some other states have tried as well. What do you think of this approach to curtail abortions from a legal standpoint?
Well, that's one of those questions I have to be careful as a candidate for the bench. I can't be prejudging issues that might come before me.
Yep.
I certainly feel like that is something that is not a federal issue, that is a state issue, and it's up to the states to determine how to handle that. And if that's how they've determined to handle it, that's at least a step in the right direction of taking action on that issue to protect against abortions.
We'll give a little flavor of historical perspective. Share your favorite founding father or American historical figure, and something about him or her that we might not know, or why they're your favorite.
Well, I think that Thomas Jefferson is probably my favorite founding father because of his role in helping to draft the Constitution, and because of also his support of trial by jury, and which is a protection that we need in order to be able to have our rights. But I also, something about Thomas Jefferson you may not know, he was also an architect, and and designed buildings, and if I remember correctly, he was the father of crop rotation. So he was a well-rounded person.
And you can actually see an example of that if you go to Monticello, which I've
Yes.
been to several times. Have you ever been disciplined, reprimanded, cited for breach of ethics or unprofessional conduct by a court, administrative agency, the Bar Association, disciplinary or grievance committee, or other professional group? And if so, yes. Explain.
One time, 30 years ago, a judge listened to an attorney who was not telling the truth and sanctioned me. I had a rehearing. He realized that that attorney was not telling the truth, and in fact, I think that attorney ended up getting his license suspended because of what he had said. Your question was very broad, so he did sanction me. It was a $500 sanction. That was removed, and I'm proud to say I've never been sanctioned, had a sanction upheld, or had a grievance or a discipline against me by a court or a state bar.
Awesome. I'll take a 20-second sidebar and say, I always ask that question, and recently someone took issue with me because they thought I was going after them personally because they in fact had been sanctioned and I did not know it. That was a lot of fun. What does the First Amendment mean to you, and what would you consider an appropriate or appropriate limitations?
I don't know that there are appropriate limitations. We have the case talking about shouting fire in a crowded theater. You can't incite someone to riot. That would be the only limitation on the First Amendment. To me, I think we have a problem in this country because we have people who have lost sight of the fact that the First Amendment does not protect you from being offended. I mean, you have a right. You don't have a right not to be offended. You have a right to say what you want to say, and I don't think there should be any limitations on that, even though there's going to be hate speech and things that we don't find popular. We need to protect the First Amendment because we don't want it to be used to preclude that kind of speech, which we do believe in, and what we're seeing now, where you have to pay to be able to speak on a campus. And if you want to espouse a conservative view, and that's just not right. The First Amendment extends to all of us, not just one side.
Similar point on the Second Amendment, what it means to you, what's a reasonable limitation?
I don't know that there is a reasonable limitation if you're talking about the right to bear arms. I know there's been some suggestion that it's only a right to bear arms if you're a member of a militia. The court has thrown that out and said that's not correct. So I don't believe there is a limitation, and that we do all, each of us, have the right to bear arms and to protect ourselves, particularly in our homes.
Well, as an example, this is a court building, and under Texas statute, we cannot carry, except Mr. Knapp, in this building.
As long as the court is in session, that is correct.
Exactly. So just the types of limitations. When is a judge justified in striking down a legislative act?
Only if it is clearly unconstitutional. Judges should not legislate from the bench. They should not set aside a law or an act unless it is clearly in violation of the Constitution, which is rarely going to be the case. We have a principle called judicial restraint that goes back to the days of Marbury versus Madison and Judge John Marshall, that judges are supposed to follow the law, apply the law as it is, and only in limited circumstances set aside a law, and that would be only if it was clearly unconstitutional.
Our lightning round is next, but I'm going to add a question based on something you said a moment ago. You used the phrase hate speech. So tell me what that phrase means to you, and should there be a such thing as hate speech that is prohibited by the law?
I don't believe it should be prohibited by law because it comes within our First Amendment right, freedom of expression. I think hate speech is examples of hate speech would be speech that's aimed at any particular group of people in an attempt to embarrass them, disparage them, or denigrate them, and that would include not only minorities, but it would also include Christians and conservatives. You have people, we've seen a lot of examples of that lately, now that President Trump's been elected, where we have we have public figures and comedians and actors who are saying the most horrible things about our president. I think that's a form of hate speech, but it falls within their First Amendment right.
And should not be illegal.
It should not be illegal.
All right. Lightning round, there's I think about 8 of them, pretty straightforward. Yes,
Okay.
no, or pass.
Okay.
And then you will have a 1-minute closing statement. And the end. You've already addressed this one. So, have you ever been convicted of a felony?
No.
Would you oppose any effort to terminate current practice of opening meetings or court sessions in prayer?
No, I would not oppose.
Have you voted for a Democrat?
Wait, I want to make sure I understand the question. I'm in favor of opening meetings with prayer.
Yes. Have you voted for a Democrat in the last 20 years?
No.
Have you ever donated money to a Democrat candidate or office holder?
Yes.
Have you ever been charged with a felony?
Yes.
Are free speech zones on college campuses constitutional?
I don't think there should be a zone. I think the
Yeah,
whole campus.
yes or no, and they can come back to you. This engages them with you.
No.
In general,
No.
okay? And again, not gotcha, go talk to it. In general, should all illegal aliens be sent back home?
No. In general, no.
And then finally, that wasn't mine, we put it in there anyway. Pick one word, any word of your choice that best describes you. One word, take a moment.
Attorneys can't do anything in one word. Experienced.
Awesome. And you see why I do this. So it engages us, it puts them on the spot for a moment, but then it elicits opportunities for discussion with the candidate. Thank you very much. Now we're going to give him an opportunity to do a 1-minute closing statement.
And in lieu of my closing statement, I may get to that, I want to address some of the things that we had the yes or no. As far as illegal aliens, I believe we should protect our borders, and I believe that if you're here illegally, then yes, we should enforce the immigration laws, and with due process, you should be sent home. I don't believe anyone should be here that's not legally here. Yes, I was arrested over 30-something years ago, almost 40 years ago. I was supposed to be starting school. It was the end of summer. I was with a buddy who I'd gone to school with. We got in an altercation with another gentleman. His dad's shotgun was in the back because it was about time for dove season, and he had gotten it, picked it up at the shop that day. He picked it up and pointed it at someone. I interceded. I got charged. They had an examining trial. At the examining trial, the victim said, no, he diffused the situation, meaning me, and it ended up getting no bill. It was handled by the Dallas County District Attorney's Office, and that same District Attorney's Office hired me to be a district attorney some 5 or 6 years later. So I think I may have stopped someone from getting killed that time, but I did get arrested for a felony.
All right. So
and I see that I'm out of time. So.
We'll extend you 30 seconds. Give him a closing statement.
Okay. Again, thank you all for having me here today. I do believe I'm the most qualified candidate for this particular race. In particular, I've handled over 120 appeals. I've had nearly 100 jury trials. In fact, I've had probably 50 in the last 5 years, including maybe 15 or 20 last year. We had a very busy year. I have seen what it takes to try cases correctly. I have read hundreds, if not maybe 1,000 transcripts, depositions, and I know from my days as a district attorney working for Mr. Wade in the appellate section what it takes in order to be a good appellate court judge, and that's why I'm asking for your vote in this case, in this race. If y'all have any questions, I'll stick around afterwards and I'll be happy to answer them. Thank you for your time and your attention. God bless you, God bless Texas, and remember when you get to voting,
Mr. Pikl, welcome. Good to see you again. 2-minute opening statement, and then after that, we're going to do about 9 questions that are 1 minute apiece, another 4 that are 2 minutes. We'll do a lightning round, and you'll have a 1-minute close. So a 2-minute opening statement.
Okay, thank you. My name's Jim Pikl. I'm running for place 12 on the 5th Court of Appeals. Most people in this room know me, including my opponent even. 31-year litigation appellate lawyer. I'm the most experienced appellate and trial lawyer at Sheaf & Stone, which is the premier law firm in Collin County. I've been involved in huge firms. I was at Weil Hamilton, which had 150 lawyers, and I've been in my own practice. I've been in small firms. Chief and Stone only had 30 lawyers when I joined it. Now it's got 65. And I tell you that about Chief and Stone mostly because I'm not running for this position because I need a job, okay? I'm not running for this position for the money, and I'm not running for this position for the commute, okay? Because I gotta leave Chief and Stone, which is like family to me. I built that firm. I'm gonna take a 6-figure cut in pay, and I gotta drive from McKinney to downtown Dallas every day. So I tell people that, and they're like, you're not smart enough to be on this court. If you're willing to sacrifice all of that to be on the Court of Appeals, why are you doing that? And the reason's really simple. The reasons couldn't be more simple. Not only is this sort of the trajectory of my whole career, but at least 50 appellate lawyers in North Texas have called me and said, this is your spot, you need to run for this position. You're the only person in the race that's qualified to do it, and more importantly, you're the only person in this race, even now, that can win in November. I've got over 400 endorsements. I've raised over $70,000. My opponent hasn't come close to any of that. I've been to I went to 229 meetings. I've worked for 10 months at this, and I'm going up against Ken Moberg, who used to be the Democratic Party chairman in Dallas, and he has $350,000 in the bank. If this party puts up a weak candidate against Ken Moberg, Moberg will spend that money and he'll take this seat. And if he takes this seat from that perch in 2020, he'll take 2 more seats for the Democrats, and in 2022 he'll take 2 more seats, and we will lose this court by 2026. So I have all that on my shoulders, and I'm still willing to do it because I want to serve. Thank you.
Thank you. And you have your time keep in the back, and I'll try to tap.
I'm
So let's start with our questions. They start with the easy and get progressively more difficult.
Okay.
How many primary or general elections in the last 10 years have you failed to vote in?
0. I just voted in my 21st Republican primary election. 21 in a row.
All right. 2, how long have you practiced law, and share any board certifications, awards, or honors you've received that are relevant to the practice or the court you're running for?
Practiced law for 31 years. I've done law, I've done litigation and appeals both in state and federal courts. I've been in 8 state courts, 14 courts of appeals, including 9 federal courts of appeals, and I've been to the United States Supreme Court 9 times. I'm board certified in consumer and commercial law. There's only 74 lawyers out of 87,000 lawyers in Texas that have that board certification. My opponent also has board certifications. Unfortunately, his aren't really relevant to being on the Court of Appeals because one's in civil trial law, one's in personal injury law, and one's in workers' comp law. My board certification in consumer and commercial law spans, well, somebody once described it, if criminal law is a planet and family law is a planet, commercial and consumer law is the rest of the galaxy. It's the hardest board certification to get. There's only 74 people that have it. I've also been appointed as an associate judge in Collin County Probate Court. So I hear mental health cases now for Judge Copeland. I've got the Founders Award from the Alliance Defending Freedom. One of the associate lawyers for the Rutherford Institute.
There we go. I'm going to try to keep on time with
Okay.
you, so he's
Sorry.
stop. That's okay.
It's hard to describe that long a time in 1 minute.
Number 3, describe to us an organized approach that you would take to handle the immense workload of the appeals court. Same as I told your opponent, if you want to share the difference between the district court and appeals court, why that workload is going to be significant relative to, say, a district court position.
The difference between the district court and the Court of Appeals is if you think about games, the district court is like a pinball machine. There are things going around all the time. I mean, you've got witnesses and bailiffs and clerks and court reporters and jurors, and you're making 50, 100 decisions an hour on a split second. You have to make your decision like that. You don't have 4 hours to go think about whether that piece of evidence comes in. You got to make a decision like that. Therefore, trial judges make a lot of mistakes. It's not because they're stupid. It's just because there's so much going on, they can't know it all. The Court of Appeals is like a chess game. It's very cerebral, very calm, no witnesses, no police officer bailiffs, nothing happens quickly. You have a lot of time to think, introspect, collegially get with your other justices on the court and make the right decision. So the two courts could not be more different. And being a trial court judge, a lot of appellate judges say it's actually a disadvantage to go on the Court of Appeals because they're so different. I like that, huh? Crazy picked it up.
Well done. Share some examples of the most common procedural mistakes made by trial judges. Since you're going to be the arbiter.
Well, that's hard to say because every case is different on its facts. I think you see a lot of appeals and mandamuses on erroneous decisions on injunctions. An injunction is a court order telling a party to do or not do something, and the court can enforce that through the contempt power. So those injunction matters are immediately appealable to the Court of Appeals because they're so important. I mean, a trial judge can shut your business down with a stroke of a pen, and so you have to be able to appeal and get that reversed. A lot of procedural decisions, mistakes made in the trial court revolve around the injunction practice. The other thing they make a lot of mistakes on is when it's called abuse of discretion. We got to give our trial judges a lot of slack on a lot of different areas. And sometimes they get themselves, in the heat of the moment, they start to get emotional themselves about what they're hearing, and they go off the rails a little bit. So you see a lot of abuse of discretion cases at the Court of Appeals too. And again, it's not criticism of trial judges, they're human beings. I mean, we're all like that. You don't put on a robe, it doesn't destroy your humanity.
Explain, we're going to switch to a famous case. I'll give the same luxury to you that we gave your opponent. Explain the facts, the pertinent facts of the Kelo decision and how the Supreme Court came to its decision, and if you feel it was decided wrongly. Before you do that, and if you don't like to do the Kelo decision, you can pick a Texas Supreme Court decision with which you know the facts of and disagree.
No, I'll do Kelo. Kelo versus New London, Connecticut was a case where New London decided that they were going to use their power of eminent domain to take a piece of property away from a private landowner and give it to, not the government, another private landowner. The theory being that if that new owner is going to do something that's going to create jobs, it's going to do something that's going to eliminate blight in the neighborhood, is going to do something that has a public purpose, raise tax revenue, that's the functional equivalent of the government taking it for a government or what's called a public use. And this is clearly a private use. It's not a public use. But the Supreme Court said if it's close enough to it, then it can be, you use eminent domain to get it. 5-4 decision, Justice Kennedy in the middle. Was it wrongly decided? I don't have enough time to talk about that.
No is the answer to that question. I mean, yes, it was wrongly decided is the answer to that question from a non-attorney. Name a judge, locally, state, or national, with which whom you greatly admire, and then please explain why.
I like Don Willett. He went on the Texas Supreme Court. He's now on the Fifth Circuit Court of Appeals, the federal court. Don Willett is a really great judge because he's funny, super articulate, and like crazy smart. I mean, and his writing reflects all of those things. He wrote a decision, and you probably have heard about this. It was I'm trying to remember the name of it. I've got his concurring opinion on the desktop in my office. I read it every once in a while. Eyebrow threaders in malls, you know. The Texas administrative agency decided they had to get complete training as a cosmetologist to do eyebrow threading. And the Supreme Court struck that down, and Willett wrote the most amazing concurring opinion where he basically just explains what a free market legal system looks like. And it's brilliant, fascinating. Guy's amazing.
Tell us about an accomplishment that you are most proud of. It could be personal or professional.
Well, since Sharon Alberson's sitting here, I'm going to have to say marrying Joni. No, I think raising my family. I raised my family through 3 kids, 2 girls and a boy, obviously with a huge amount of help from Joni, because I came, as most of you know, from a very dysfunctional family and didn't know anything about parenting. But my kids have all turned out amazing, and I credit Joni for that, because if I had been in charge, they would have been wrecks like I was when I was growing up. But to look at those kids now, when I was married, I had my first grandchild, July 27th, a little girl named Anna. Super excited about that. But looking back on all the mistakes, all the things I did right in raising those children to be the adults they are now is a huge accomplishment in my life, especially because the odds were so stacked against me given how I started out.
We're going to switch gears a little bit. The Iowa Senate recently passed something referred to as a heartbeat bill, and it effectively bans abortions after 5 weeks. What do you think about this approach to curtail abortion in America from a legal perspective?
It's a great question, and it's a great example to use about why you need judges that have a lot of wisdom, okay? A lot of legal decision-making is drawing lines between extremes. Pro-life, life begins at conception. Pro-abortion, life begins when the baby draws its first breath and the umbilical cord is cut, okay? The idea of politics and law is where do you draw the line in between those two extremes? And the five-week abortion ban, they've drawn the line a lot more this way, right? 5 weeks is like this close. As soon as the heart starts beating, that's where we draw the line. And the line in this case is where a child has fundamental, human, enforceable, protectable rights as a full-fledged human being, which means they can't be murdered. So, I mean, it's an elephant. You go from Roe versus Wade to, you know, pro-life, which is where I am. I get Texas Right to Life endorsement, and we're moving in the right direction. So,
We have 5 more that are 2 minutes apiece, starting with this one. Tell us your favorite founding father or American historical figure, and perhaps share something with us about him or her that we might not know.
I like Patrick Henry, and I know quite a bit about Patrick Henry. I've read a couple of biographies on him. Patrick Henry was a cobbler during the Revolutionary War. A man of no real repute. He wasn't an elected official or anything. He came along, and one of the challenges, one of the things that Patrick Henry did in the Revolutionary War was he blew up government buildings. He was an explosives expert. Okay, I like that because I went into through BUDS in the Navy. We learned a lot about explosives then too. But Patrick Henry was one of those people that he had really everything to lose and nothing to gain by taking up the cause of the Patriots. Now you can say that about all the founding fathers, you know, because they all put their lives and fortunes and their sacred honor on the altar of freedom. But Patrick Henry was one of those people that he did all the dirty jobs. He did all the jobs nobody else wanted. And in my legal practice, I've kind of been like that. The reason I have such a broad scope of experience in my legal practice is because I was always the guy at all of my firms that got all the crappy jobs that nobody else wanted to do. So I got to do that, and I had to learn about family law, then I have to learn about, you know, eminent domain, and anything nobody else wanted to do, I got to do it. And so I kind of relate to Patrick Henry in that way, because litigation's like warfare. And I don't blow up government buildings, but I'm the guy like him that gets all the dirty jobs.
This one's a bit tedious, but important. Have you ever been disciplined, reprimanded, cited for breach of ethics, or unprofessional conduct by a court, administrative agency, the Bar Association, disciplinary or grievance committee, or other professional group? And if yes, please explain.
Never.
All right.
In fact, for 6 years, I was appointed by the State Bar President and the Board of Governors to be on the State Bar Grievance Committee, which I sat on for 6 years. And that's the committee that judges what the other lawyers in the bar are charged with doing ethical violations. So I'm considered an expert in legal ethics because of that experience.
What does the First Amendment mean to you, and what would you consider appropriate limitations?
Is this 2 minutes?
Yes, sir.
Okay.
No, it's just one, actually.
Oh, Steve, you're killing me.
If we, whatever timing we gave to Mr. Johnson, if it's 1 minute, then it's 1 minute.
It's 1 minute.
Okay, he's the timekeeper. Thank you. That's fine.
One of my pet peeves as a constitutional civil rights lawyer is when people talk about constitutional rights. You know, one of the only constitutional rights there is, if you're 35 and a natural born citizen, you have the right to run for president. You know what all the rights are in the Bill of Rights? They're not constitutional rights. They're human rights. They're God-given rights, inalienable rights. The Constitution, especially the Bill of Rights, does not grant you rights. The Constitution prohibits the government from infringing those rights that you got from God. So if they take the Second Amendment out of the Constitution, you won't be able to carry guns. Wrong. You can still protect yourself. It's just that the government now can try to infringe it without running afoul of the Constitution. Same thing with the First Amendment. You've got the right to speak. You have the right to your religion. You have the right to assembly. You have the right to petition the government. Those are human, God-given rights. They're not given by the Constitution. The Constitution prevents their infringement. And that is a hugely important distinction when you're talking about something as something like fundamental rights. Hugely important.
Any appropriate limitations to the First Amendment?
Of course, yeah.
You can piggyback in this next one, it's very similar. What is the Second Amendment? Why does the Second Amendment exist, and what do you consider reasonable limitations?
Okay, reasonable limitations of the First Amendment. If you're going to create a clear and present danger with your speech, not good. And scream fire in a crowded movie theater, a bunch of people get trampled and die. It's not freedom of speech, that's license of speech. Freedom always comes with responsibilities, okay? And the government can put reasonable time, place, and manner restrictions for the purpose of protecting others from you, okay? But they can't protect you from yourself. That's a big difference. Second Amendment, same thing. The Second Amendment, gotta remember when it was written, less than 20 years after they just fought a bloody revolutionary war against the greatest superpower, military superpower in the world at the time, Great Britain. The Second Amendment was to prevent that from having to happen again. The Second Amendment is to protect the right of the people to bear arms so they can fight off a tyrannical, out-of-control government. It's not about hunting. It's not about protecting Granny. It's not about any of that stuff. That was the purpose of the Second Amendment. And you know what? We still need it.
When is a judge justified in striking down a legislative act?
Several times that could happen. The legislative act could just be clearly against a constitutional requirement or rule. You could have two statutes which directly conflict with each other, and that they both come into play and both can't stand. So one of them would have to be stricken. You'd have to decide which one to strike, but one of them would have to go because you can't have two things. You can't have it going right and left at the same time. Maybe if I don't like the law, maybe I could just decide to strike it down. I just seen who's paying attention. Yeah, no, that's personal opinions obviously don't come into it. Yeah, so those are at least two examples of when a law might be struck down by a court.
All right, and I added a question in the last series, so I'm going to share that same question with you relative to First Amendment rights. What does hate speech mean to you, and should we have hate speech as prohibited by law?
You know, it's all about decisions. It's all about definitions, I mean. And definitions require a definer. So somebody or some court or some legislature has to define what the word means, because otherwise it's meaningless. And so hate speech, depending on who's defining it and what they're defining as hate speech, may or may not run afoul of the Constitution, of the First Amendment, right to free speech. It may be one of those kind of situations where you would be able to regulate it, again, if it's creating a clear and present danger for the life, property, or liberty of others. Then the government would obviously, in its police power, have the right to restrict that type of speech. These days it's being used by the liberals for just anything they don't happen to like to hear. And you know, you can't say it because it offends me. You know, I was telling Steve, you know what happens when you're offended? Nothing. Nothing happens when you're offended. You don't grow another arm, pieces of you don't fall off, okay? Nothing happens, okay? So this being offended by somebody's speech, I mean, just because it doesn't happen, you don't happen to like it, I got a problem with that.
All right, lightning round, yes, no, or pass.
Okay.
8 questions. I'll cut you off, and then you can explain afterward. And then you do have a 1-minute closing statement.
Okay.
Have you ever been convicted of a felony?
No.
Would you, this one seems to be tricky, so listen. Would you oppose any effort to terminate the current practice of opening meetings or court sessions in prayer?
Repeat.
Would you oppose efforts to terminate the practice of opening meetings or court sessions in prayer?
Efforts to terminate. It's a double or maybe a triple negative.
Yeah, I didn't answer that. The idea is...
I think groups should be able to open in prayer if they want to. How's that? Just saying.
Have you voted for a Democrat in the last 20 years?
I've never voted for a Democrat.
Yes or no or pass?
No.
Have you ever donated money to a Democrat candidate or office holder?
No.
Have you ever been charged with a felony?
No.
Are free speech zones on college campuses constitutional?
No.
In general, should all illegal aliens be sent back home?
In general, yes.
Pick, and then ponder on this one for a moment. This is your last one. Pick one word that best describes You, one word.
Yeah, tenacious.
All right.
Unfair.
And then 1 minute closing statement for us.
I'm the only person in this race right now that's a military veteran. I'm the only one that has any judicial experience. I'm the only one who's been to the United States Supreme Court. I'm the only constitutional expert that's testified in front of Congress. I'm the only one board certified in a field that actually matters to the court. I'm the only one in the race that's qualified by the nonpartisan Committee for a Qualified Judiciary. I have over 400 endorsements, 82 precinct chairs, 60 elected officials, 300 activists, 11 conservative groups, and I've raised more money than both my primary opponents put together times 5. But Proverbs 27:2 says, "Let another man praise you and not your own mouth." So here's from somebody who actually knows something about this job. Get the right one here. I was blessed and honored to serve on the 5th District Court of Appeals for over 18 years, and I've known Jim Pikl for a long time, both professionally and personally. Jim possesses the legal expertise, wise judgment, and personal integrity that will make him a successful and respected justice. I'm confident he will faithfully apply the law and will give each case the care and unbiased attention it deserves. I am proud to give Jim Pikl my very highest endorsement, and I encourage everyone to help elect him to this important position. Signed, Justice Jim Mosley, 5th Court of Appeals, retired. This guy knows what the job takes. I've known Jim Mosley for 30 years. He knows that I'm qualified for this job. I would like to see anybody else with this kind of recommendation run for this office. If they had, I would drop out. But there isn't anybody doing it. I'm the only one that can win in November. On November 7th, election's November 6th. On November 7th, you're either going to be saying Justice Pikl, or you're going to be saying Justice Mulder. Those are your 2 choices.
About what's right. Our American, taking back our country, come and join the fight. Our American, somebody's gotta stand up. Somebody's gotta do what's right. We're rising 'cause we're fair.